Alright, this is the one video about the Warren court cases. Now, some of these took place in the 1950s, but the bulk of them, let me check real quick, took place in the 1960s. Now, Earl Warren is the most liberal Supreme Court justice. That means when a court case comes to him, rather than being strict and going by the exact letter of the law, he's going to interpret and embellish, and he's actually going to promote new rights and new understandings as far as the Constitution is concerned. And many of these we've heard of before, but I'm going to go through them. The page for your notes is a little bit different. You simply have to fill in the court cases because there's a lot of information. But please listen, highlight the stuff I'm talking about. The quiz will be matching much like the New Deal programs. Okay, here we go. So, as I said, a liberal Supreme Court. You can see kind of this wordogram. The biggest word is interpretation. Okay. What did they mean when they said due process? What did they mean when they said, double jeopardy, etc.? We're going to really embellish and say what they meant to say was this, and the spirit of the law is this, okay? That's the main thing to keep in mind as we go through these slides. Now, the one that really kicks all this off is in 1954, a father and his daughter, Linda Brown, will sue the Board of Education of Topeka, Kansas. Now, little known fact, maybe this is not the only case here. It's actually 6 different court cases combined into one, but Linda Brown and her father are the focal points. They're the ones that had to move and avoid the death threats and all this stuff. Now, what are they actually challenging here? They're challenging separate but equal in schools. Because this is kind of a follow-down effect. If separate but equal can't exist in schools, then little by little, this era of segregation and Jim Crow will end. So, in a massive court decision, they actually rule that segregation in schools is unconstitutional. Now, I'm not going to go much further here, but when I get to civil rights, I'll tell you about the nail in the coffin, what really sealed the deal here, okay? So, there you go. Now, the next court case in 1961, we had the Mapp versus Ohio. Now, Miss Mapp, I call this the old dirty woman case, okay? They were searching for something, she knew something. They found something to be illegal. They took it, and they tried to use it against her. However, they didn't have that paper. It's called a warrant. So, this is going to strengthen that idea of search and seizure, the Fourth Amendment, and you must have a warrant if you want to use something. Otherwise, as we learned in the Mapp case, evidence without a warrant is inadmissible, meaning you can't use it. Okay? So again, strengthening what was said earlier. Now, in 1962, we have an interesting court case of Engel versus Vital. Now, the way I like to remember this is Engel is German for the word angel. So this involves religion. Now, in the First Amendment, part of the First Amendment says the U.S. government shall not establish a religion. Okay? The country, at this point, is very Christian, and there's other things. And Mr. Engel felt that his belief as an agnostic were being pushed aside. So, the Supreme Court says you can't have mandatory school prayers. You can't sit there and say, okay, here's our morning prayer. You can't do that. Now, if you want to do it on your own in a silent time, moment of silence, which moment of silence, that's a big debate today. And so that's what all applies onto this one. Now, also in 1962, we have the establishment of Baker versus Carr. And you see right there, one man, one vote. Now, a big deal, and this harkens back to the way a slave was actually defined in the Constitution, that a slave was actually 3/5 of a man, not a whole man. So, Baker versus Carr is one man, one vote. Now, in 1963, we have a petty criminal named Mr. Gideon. Mr. Gideon can't afford a lawyer, etc., and so he can't represent himself. He's thrown into jail. Going back to the due process, they establish if you cannot afford an attorney, one can be appointed for you. It's called pro bono in the law world. They have to establish some time for doing some free court cases. So, to protect yourself, you can be given a lawyer. They may not be the best one, but nonetheless, it is there for you. Now, 1964, and this goes back to the Fifth Amendment and the idea of self-incrimination rights of the accused. We have Malloy versus Hogan. Now, Malloy versus Hogan, you do not have to testify in a court case where you could be indicted or implicate yourself in some type of crime. So this goes back to the, as Dave Chappelle put it, I plead the fifth. 1, 2, 3, fifth. Chappelle Show is a great show, and they talk about that. But you have the right to use the Fifth Amendment. Now understand, if you do, people perceive you use the Fifth Amendment, you are in fact guilty. So be very wary if you do decide to do that. Hopefully, you're never put in that position or put yourself in the position where you have to use Fifth Amendment. Anyway, here we go to the next one. Now, in 1964, a similar court case to Baker v. Carr, Reynolds v. Sims is established, okay? Now, Reynolds v. Sims, okay, has to do with residents of Jefferson County challenging the appointment. They said that the courts had essentially been fixed, and this is going to outlaw the big court case that we called gerrymandering, okay? Now, gerrymandering is where you kind of fix the court cases or the court districts so that the same people get voted in again and again and again, because famously Congress and lower justices do not have term limits. You can be voted in as many times as you want. In fact, the only politician with a term limit is our president. So, fun stuff there, okay? Now, 1964, we have Escobedo versus Illinois. Now, Danny Escobedo was arrested, and while arrested, he began to confess to a crime. When he got to court, however, he said, I was not made aware of the fact that I could have a lawyer, and I didn't have to answer these police questions. I felt nervous. So what they actually said is, and the precedent or the ruling established here is, you may have an attorney present during police questioning. Okay? And this is why you see the TV show and they get uppity, I'm not answering any of your questions until I get a lawyer. Now, remember, the way you say it can get you in a little more trouble. So understand your right, but also be a little bit understanding, if you will. Now, also 1964, this one involves Dr. King. Heart of Atlanta Motel versus U.S. Dr. King had gone to visit in Atlanta, and he was denied lodging at this Heart of Atlanta Motel. And they said, well, we have the right to do whatever. They establish here, if you are a hotel and you are set up within a city district, you have no right to discriminate based on race, sex, gender, creed, origin, etc., whatever. You have to give them lodging if you have space. You can't sit there and deny them. So this goes again, another kind of chopped down for separate but equal. And we really see things picking up at this point. That's good. Now, in 1964, we have the New York Times versus Sullivan. Okay? Now, here, this is going to establish a bigger thing for free press. There's actually a court case that is called a libel case, and that's L-I-B-E-L. Libel means you're trying to slander somebody. You're trying to ruin their reputation, okay? In order to prove that you want to ruin someone's reputation, according to this court case here, the court has to prove that there had been an intent of malice. In other words, I really hate this person. I want to see them suffer, so I'm going to ruin their name. And so that's what they established there. Freedom of the press to print what they want is established. And it's a fairly big deal, okay? Other court cases like this were Neer versus Minnesota, U.S. versus New York Times, etc. All those things are established, okay? Now, 1965, this now deals with women's rights. Connecticut had a law that said they would not sell you contraception, that is, birth control pills and other contraceptive devices to prevent pregnancy. Ms. Griswold, seen here, is a big supporter of Planned Parenthood, the idea of a woman's right to privacy involving her reproductive systems, etc. And so they establish here that no state can get between a woman and her privacy rights. And so contraceptive pills and things like that become a big deal in 1965. They become very commonplace. They're able to be purchased with a doctor's note fairly easily. And so that kind of continues today. Now, 1966, this is the biggest one because everyone can almost say this verbatim. If you're watching Law & Order SVU or any cop show, they'll pull someone over and immediately they will, as they're cuffing them, tell them, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be appointed for you. And so this is what we call the Miranda warnings or the Miranda rights. It's named for Ernesto Miranda. Now, Ernesto Miranda was arrested. He said, I didn't have the right to know how an attorney. I didn't have the note that I didn't have to answer the questions while I'm being interrogated. They should have told me these things, okay? This is part of due process, and so they strengthen the due process again to say that if law enforcement wants to pick you up, they have to issue the Miranda warnings or they must let you go. All right. Now, in 1967, the couple seen here is the loving couple, aptly appropriate name, right? They wanted to be wed in the state of Virginia. However, Virginia said, we will not marry an interracial couple. So at this point, Angelina Jolie and Denzel Washington couldn't have gone and gotten married. Okay, I'm just using an example here. Okay, but in the Warren Court, they ultimately decided interracial marriage is okay. You can't ban it. If you're going to have it for everybody, you have to have it for them. This is actually a kind of a building block of the same-sex marriage laws that were passed recently in this country, and so they use this as kind of a stepping stone. That's why the easy way to remember that loving, and it's kind of appropriate. Love sees no colors, it sees no boundaries, etc. Now, 1967, we have Katz versus the U.S., okay? And I like to call this the Donald Sterling case. And if you have no idea who Donald Sterling is, I will share it with you in a minute. Mr. Katz was recorded saying some things. When he went and was arrested, they used these recordings against him, and they had to excuse what they had. The reason is, if you're going to record somebody and use it in a court, you must warn them that you're being recorded. This is why all those, you call somebody and they go, warning, these calls are recorded for training purposes. They're also there to protect themselves in case something does happen, and they use it in court. They're telling you up front, okay? Now, why Donald Sterling? Donald Sterling was the owner of the Los Angeles Clippers in the basketball league, okay? Now, Donald Sterling had a wife. He also had this kind of girlfriend, mistress, who was much younger than him, and he went to her very early in the relationship and said, I need you to record me on a nightly basis because I may want to hear what I had to think. I may have a big thought, okay? Well, this actually came back to bite him because on one night he made some pretty derogatory comments about African Americans, about black people. In particular, one Magic Johnson who played for the LA Lakers. And so these things came to light, and ultimately they used this against him, and the NBA and the U.S. Government more or less kind of put pressure on him to sell the Clippers because of these. But was this legal? Absolutely, because he asked to be recorded, and they said, we're going to use these recordings against you. We have two more. Stay with me, I know. Now, 1969, we have Brandenburg versus Ohio. And the symbol that you see there in the picture is the big thing. Did the KKK have the right to burn a cross? A big thing that's been going on for many, many years, okay? What they decided in Brandenburg versus Ohio is that inflammatory speech is okay. You're allowed to say these inflammatory speech so long as, okay? And you can see it there, right? It can only be prohibited if it's directed at inciting something imminent, a lawless action, or it's likely to incite or produce such action. The burning cross was an example. You can't do that because that's directed at somebody. That's basically saying, I'm going to, even not even Jesus can save you to an extent. And it's a horrible mentality. Um, and this goes to the current movement of Black Lives Matter. I keep bringing that up. But they're allowed to say these inflammatory things so long as they don't say death to the cops or something like that. That's not protected. But they're allowed to sit there and say, we're not treated fairly, we don't think we're getting the right treatment, etc. They're perfectly legal in that right, okay? Now the last one. In 1969 as well, there is a court case of Tinker versus Des Moines. These are high school students. They went to their school in Des Moines School District, and they wore a black armband with a peace symbol on it. They were expelled from school. The peace symbol had been, at this time, a movement of the counterculture and the anti-war movement and everything like that that became so strong and synonymous with the hippies and the music of the 1960s. So they sued the school district. Ultimately, the Supreme Court said they are allowed to do this because it is symbolic speech. And symbolic speech can't be punished so long as you don't infringe on anyone else's right or step on anyone else's toes. So all of these court cases together make up what we call the Warren Court. This is probably, as I said, the most liberal era of promoting rights and expanding things and interpreting the law. It was a little bit longer video than my other ones, but this is the only one you had to watch. You might have to watch it twice because there's a lot of information. All right?